Grikas. I'm the chair of the committee and I'm a state bar counselor. We are lucky to have a number of guests here today. We have folks from the Ontario Law Society who are going to talk to us, as well as folks from the North Carolina Justice for All Project who are going to talk to us. So I'm excited to have some guests. We circulated the agenda to all the committee members ahead of time. It's got a lot of good material in there, both about the Ontario program. We also have the PowerPoint and the written report from the NC Justice for All folks, as well as information on the New York Court Navigator program, which if we have time, we'll talk to at the end, although I think we're going to have a pretty full agenda. I do want to start by reminding all committee members about their obligation to avoid conflicts of interest, in the appearance of conflict of interest, in the performing the duties as a member of the committee to study regulatory change, and as members of the North Carolina State Bar. Any members of the committee who are aware of any personal conflict or appearance of conflict should disclose those at the meetings. Anybody have any conflict of interest they need to disclose here at the outset? If not, we'll go ahead. We have one quick business matter, which is approval of our minutes from the January 26th, 2021 meeting. As you may recall, most of that was spent learning about the Arizona program and the regulatory initiatives they did in Arizona. We heard from Dave Byers there. Again, the minutes provide a short summary. We got a lot of information, but I think Brian's captured most of that. I don't know if anybody has any corrections. If not, I'd entertain a motion to approve those minutes.
I move to approve the minutes from the last meeting.
All right. Any second? All right. That's been moved by Steve, seconded by Ashley. I think we can do that by voice vote here, Brian, rather than using it. All those in favor say aye.
Aye.
Aye. Any opposed? Hearing none, it sounds like that's unanimously adopted. And again, for visitors, we've been over the last several months, our committee was formed to really study possible regulatory change. We know a lot has been happening around the country and around the world. We're hearing from other countries, not just the United States, about how we can do better with our regulatory role, with a real focus on improving access to justice. We heard a lot about the unmet legal needs. We had a whole session meeting with the various legal aid providers. There is certainly significant needs that are not being met. And I think our role is really to look at what changes are taking place elsewhere, and then to recommend the State Bar which of those we think are worth further exploration and perhaps taking some actual concrete action on. So this is a study committee. We are looking at a number of different things and just trying to understand, what is happening, what's working, what's not working, because we know a lot of exciting initiatives are taking place. So that's the role of this committee, and we've got a mix of State Bar counselors and community members and other folks that are serving on this committee. So we do have two presentations today. Both of these are around the idea of some type of limited license paralegal, limited license technician idea. And I'm excited. We heard a little bit about that in Arizona. We're going to hear more and dive a little deeper into that. Again, I think we'll hear presentations and then there'll be opportunities for questions from members of the committee about it. So we'll start with the Law Society of Ontario. We have two guests there. We have Jessica Weiss, who's counsel and acting team lead for licensing and accreditation, as well as Nina Brickman, who's senior counsel and team manager for entry level compliance. Jessica and Nina, thanks so much for being willing to join our committee. I appreciate you taking the time to talk to us.
Yeah, we're really happy to be here. I do have some slides for the presentation. Can I share? Oh, yes, I can.
Yes,
Thank
you should be able to share your screen. Yep.
Yes. Okay. And I apologize. I am not the most technically savvy person. Okay. Can you all see the slide there?
I see the first slide. Yeah.
Okay.
Looking
perfect. Good. Perfect. Okay. Hi, we're so happy to be here. I am Jessica Weiss. I'm the counsel and acting team lead for licensing and accreditation. Just to give you a little bit of my background, I was a commercial litigator for a number of years, and I worked briefly in legal education before joining the Law Society. So at the Law Society, I manage a team that works on many aspects of paralegal licensing and accreditation, including the development of the licensing examination and the study materials that accompany the licensing examination. And we also regulate paralegal education institutions. So we accredit and reaccredit paralegal education programs at colleges, and we go in and perform regular audits and handle and investigate complaints regarding paralegal education programs. And I'm joined by my colleague, Penina Brickman. Penina, would you like to introduce yourself?
Hi, everyone. Thank you so much, Jess. So my background is not that dissimilar from Jessica's in that I also started off as a commercial litigator. I then moved in-house with various entities. I worked in legal publishing as well, and then I came on board at the Law Society. And my role straddles both paralegals and lawyers, both of whom are licensees at the Law Society. And I work in a number of different areas. On the one hand, I am responsible for entry-level competence, the paralegal education side of things with Jess's team, but I also have some responsibility for tutoring, for accommodations, and for experiential training. So it's a wide-ranging role that covers both classes of licensee. And thank you for having us.
So here is an overview of what we plan to discuss today. But please feel free to interrupt with questions. We have about 30 to 45 minutes of kind of planned content. We certainly don't need to go through it all. We'd like to focus on what you're interested in. So I can't see you because of the way my screen has to be set up. So just kind of speak up, feel free to interrupt with any questions or comments as they come up. So Penina's going to start by giving a history of paralegal licensure in Ontario. Then I'm going to discuss scope of practice. So there is a limited scope of practice for paralegals. And then we'll discuss the current licensing process, some trends, data, and kind of the regulatory framework for paralegals in Ontario. And then we'll briefly discuss the future of paralegal licensure in Ontario. But before I get into that, I thought I would kind of just let you know what the Law Society is, because I know we're your neighbors to the north. So as Penina mentioned, the Law Society of Ontario governs Ontario's lawyers and paralegals in the public interest. The Law Society has a number of duties. So we have to protect the public interest. We also maintain and advance the cause of justice and the rule of law. One of our duties is facilitating access to justice for the people of Ontario, which is one of the duties that kind of advanced paralegal licensure. And we have the duty to act in a timely, open, and efficient manner. The Law Society has been around since 1797, so we've been around a long time, initially founded as the Law Society of Upper Canada. And it started as also controlling legal education. That ended in 1957 when the Law Society maintained its regulation of lawyers in Ontario. And then in 2007, the Law Society assumed responsibility for the regulation of paralegals in Ontario. We now are known as the Law Society of Ontario, and that name change happened in 2018. So it's relatively new that we are no longer known as the Law Society of Upper Canada. Penina, I can hand it over to you to talk about some of the history of paralegal licensure.
Okay, that sounds great. Thanks, Jess. So the history of paralegal licensure goes back quite a ways in the sense of discussions about it. And that's probably similar to what has occurred in many other jurisdictions, including your jurisdiction. But really the culmination of some of those efforts that happened in the 1990s and early 2000s really took place in 2004. And our then Attorney General attended convocation, which is the body that governs the Law Society, to request that the Law Society, as Jessica mentioned, then known as the Law Society of Upper Canada, assume responsibility for the regulation of paralegals. There was a task force created And ultimately, the decision was that the scope of practice that then existed for non-lawyers should really remain the same, but that there would be a framework for licensing those individuals. And some of the individuals who were able to act before without a license to practice law as lawyers included people who represented clients as agents. So it was really you could think of it as the licensure of agents that really took place and created a framework for that. And the areas that were covered, that are covered now, are such things as appearing before tribunals, as distinguished from courts, but also appearing in certain courts, for example, on certain types of criminal offenses and small claims court. I believe our jurisdiction for small claims court is 35,000 now. So it gives quite a large scope of practice in that area as well. Do you want to advance to the next slide, Jess? So some of the goals that historically were sought to be achieved through the licensure of paralegals was maintaining the public interest, ensuring that people who were representing the public acted ethically and were competent, ensuring that there was a level of understandability, lack of complexity to the nature of the distinction between the licenses, and mirroring lawyer regulation wherever that was possible. And then some of the features that were designed in connection with those goals were the requirement of education in order to become licensed as a paralegal, a requirement of good character, licensing examination. There was a code of conduct. There was a requirement to obtain insurance. There's a compensation fund that each class of licensees contributes into a compensation fund, and also discipline for misconduct or wrongful conduct. And I just wanted to pause there for a moment to see if there were any questions, just to give you an opportunity, if you had any questions about some of those sort of very bare bones starting features.
I'm interested. This is Mark. I know you've got insurance as one of the features, and I'm curious. Some states require lawyers to be insured, others don't. North Carolina actually doesn't. I'm wondering, do you require lawyers to have insurance in Ontario as well as paralegals?
We do. So there is an insurer for practicing lawyers that all lawyers who are practicing have to participate in. And paralegals, somewhat differently, can procure their own insurance, but there are requirements in respect of that insurance. But both classes of licensee are required to be insured for the protection of the public.
Great. And you may be getting into this in terms of discipline, but is it the same entity that disciplines lawyers that disciplines paralegals, or do you have separate entities for those?
It's the same entity. So it is the Law Society Tribunal that ultimately would make a decision on discipline.
And this is Brian. I just had one real quick question. Just to get the context here, before 2007, I guess when the Attorney General made this request in 2004, was there any regulation of paralegals? Were there any requirements, educational requirements, or anything where somebody had to register to even be a paralegal, or could anybody be a paralegal and simply work with a law office?
I think that's correct, and Jess can correct me if I'm wrong on this. But prior to licensure, it was not a regulated type of activity. So that said, many people went through college courses. Some people who were law clerks would have joined an organization and become a member of that organization, but there wasn't a sort of overarching legal requirement to take certain steps. But we did have college programs for legal assistants and law clerks. There was a court and tribunal agent program, that kind of thing.
Okay, thank you.
Jess, do you want to advance to the next slide? So still staying within the history of a licensure, when the decisions were initially made, there were some grandparenting provisions for people who had already been practicing as agents or paralegals at the time before the licensure requirements. And so there were grandparenting provisions put into place so that there was an examination requirement, good character requirements, but that there was not an obligation for some people to go back to do a brand new educational program, etc. There were also some exemptions that were available, and some of them were time limited. So, for example, people who are justices of the peace or who have had certain full-time roles with tribunals might be exempted from some of the requirements. So there is a bylaw that sets out the list of some of those time limited and some not time limited exemptions from paralegal licensure requirements. There are also some exemptions that have been put into place. So it looks like there might be a question. Nope. Okay. So there are some exceptions as well from licensure for certain types of activities, because, for example, somebody might represent one of their family members, somebody who's unlicensed, and their friend perhaps has a ticket, and they might ask them to represent them. So there are some exceptions that are put into place, but they also have restrictions contained in some of those. And that's really to allow the continuing function, essentially, of certain less risky types of situations. And then ultimately now, for the people who, if you could just go back one slide, Jess, for the people who are becoming licensed paralegals, there's a licensing examination that includes substantive law, but historically, the initial version of the licensing examination was really focused on ethics, professional responsibility, and practice management. Now we can go to slide number 6, thanks. So currently, we have a few exceptions and exemptions that remain in place within the bylaw. But other than that, the requirements for the vast majority of people who effectively are representing the public as paralegals remain quite consistent. And there is a licensing examination that covers both substantive law as well as professional responsibility, practice management, and ethics. And I'll say one more time if there are any questions before I turn it back over to Jessica.
I guess, and you may be covering this later, but I'm curious as to how many paralegals kind of operate on their own, in other words, their own firm or individually, and how many are part of law firms. Here certainly many, almost all paralegals in North Carolina work in law firms. Part of that's the supervision requirement, but that's kind of the business structure. And since you've got, paralegal licensure, I'm curious if you have some sense of how many are in their own, operating their own business entities as opposed to being part of law firm entities.
So we do have some data coming later. Jess, I'm not sure if we have data on.
We don't have data on that, though I do think we collect some data on that that's likely in the annual report that we could share. Penina, correct me if I'm wrong, but many licensed and practicing paralegals, who are practicing delivering legal services, operate on their own.
That's correct. And sometimes they work, as a 2-person firm, or they might work in a 5-person firm. So the size might vary, but there are many who are practicing and representing clients, as licensed paralegals.
Thanks, that's helpful. Go ahead.
I'm curious if I could ask a question about there was a category of agents prior to your licensing paralegals. Is that right?
So it wasn't a category of licensed people. That was it. It was people who were acting as agents for people. And that was part of the thinking around the licensure of paralegals, is who are the individuals who are representing the public in some fashion in a way that's something that was sought to be brought into the panoply of regulation.
How did you get to be an agent? This would be a person that could go represent the friend in a traffic case or go to small claims court or that kind of thing?
So there were a number of arenas that weren't at the time governed by the concept of required to be licensed as a lawyer. And so those arenas were what was captured by sort of individuals who acted as an agent for someone. representing them in some fashion.
And you just step up and do that.
Well, there was a court and tribunal agent program, I believe, at some of the colleges, for example. So I do think that many people did undertake educational training for some of those activities. But not everyone necessarily would have. So for example, you might have had someone who was previously engaged with the justice system in another fashion. I'm thinking, for example, of perhaps a police officer who might be retired, who then might perhaps represent someone on a traffic ticket.
Okay, thank you.
And I should say, just for clarity, that that situation was really before my experience at the Law Society. So I won't have the same level of depth of knowledge as people who would have been involved at the time in the transition to paralegal licensure, but we probably could find some of that historical information and provide it to you.
Thank you.
So scope of practice, and Penina touched on this. Scope of practice, the intention was for it to remain the same as it had been before. And scope of practice is one of the items of kind of paralegal licensure that can get complicated. It doesn't seem on its face like it's that complicated, but it can get complicated. So I'll go through it briefly. So as Penina mentioned, paralegals can act before the small claims court. These are civil matters up to $35,000, or actions for recovery of property valued at up to $35,000. Paralegals can act on all matters before the small claims court. They can also act on before the Ontario Court of Justice on Provincial Offences Act matters. So these are quasi-criminal offences, Highway Traffic Act offences, municipal bylaw charges, charges laid under other provincial legislation, such as the Environmental Protection Act, Trespass to Property Act. Many of these offences are not very serious. Many of them result in a fine, but some of the more serious ones could end with a jail sentence. Paralegals can also act under proceedings under the criminal code before a summary conviction court. So in Canada, under the criminal code, there are summary conviction offenses, which are those less serious offenses. And then there are indictable offenses, which are the much more serious offenses. This one is a little bit complicated because prior to September 2019, there was a provision in the criminal code that said that agents could act on these offenses that carried a maximum term of imprisonment of 6 months or less, or a fine of $5,000. And that was kind of the way that paralegals had standing to act on summary conviction offenses before the Ontario Court of Justice. In September 2019, the criminal code was amended so that the maximum sentences were now 2 years less a day of imprisonment for most summary conviction offenses, which pushed many summary conviction offenses out of scope because paralegals could only act on summary conviction offenses that carried a maximum of 6 months imprisonment. Scope, I should say, is all within one of the bylaws made under the Law Society Act. And if you actually take a look at the bylaw, the language in this item is a little bit confusing. It talks about the amendment day. Essentially what happened was that scope remained the same as it had been before September 2019. So any matters that paralegals could act on before the change to the criminal code, they could still act on, keeping scope the same. But in effect, it broadened scope because now paralegals were acting on matters that could result in a much longer sentence in jail. And I should mention that paralegals can't represent youth under the Youth Criminal Justice Act, which applies the criminal code to youth who are 12 to 18 years old. So paralegals cannot represent youth.
Jessica, I know one area we see a lot of unmet need is landlord-tenant proceedings as well as family court proceedings. Is landlord-tenant in your small claims court, or is there a separate court for that? And what about family law?
Yeah, so landlord and tenant is under the next item, which is
Okay.
administrative tribunals. Any administrative tribunals established under federal or provincial legislation. So that is the Landlord and Tenant Board, the Human Rights Tribunal. Family law is not part of scope. And that's actually an interesting one because that's one of the items that we were going to touch on at the very end, that the Law Society is currently looking at taking comments from the public and from licensees about the possibility of effectively creating a new type of license that would build on the paralegal license to broaden scope to include family law with some type of additional schooling or training and assessment.
It might, oh, sorry, Jess, I was just going to add, I wonder if we should just explain a little bit about the types of tribunals that we have. So just giving some examples you mentioned in terms of residential tenancies, but, you know, securities is before a tribunal. There are a number of areas, you know, I think Jess mentioned human rights. So there are a number of different areas where in Ontario, it's a tribunal rather than a court that would adjudicate the matter. Even the Law Society Tribunal is a tribunal.
Yeah, that's right. And another interesting one under the tribunals is the Immigration and Refugee Board. So immigration, paralegals can appear before the Immigration and Refugee Board and provide legal services for matters that relate to a board hearing, but they cannot otherwise provide immigration services. So drafting documents or providing any legal services not related to a board hearing are considered out of scope for paralegals. Another one of, it's a tribunal, but it has kind of its own category is the License Appeal Tribunal, which adjudicates statutory accident benefits schedule claims. So these are the no-fault benefits that insurers provide after a car accident, and they're mandated by the Insurance Act in Ontario, and paralegals can act on those types of matters. So anything that falls within scope, a paralegal can act on and give advice within, so long as there is a proceeding or an intended proceeding. So this is another item that can get tricky. You know, for example, demand letters. If a client comes to a paralegal and says, you know, I want to go to small claims court, but the first thing we're going to do is we're going to send a demand letter to the opposing party, that's fine because there is an intended proceeding. The client intends to proceed to court. A paralegal cannot act or send a demand letter for a client who does not intend to proceed. That would make it out of scope. Anything that is within scope, so long as there is a proceeding or intended proceeding, the paralegal can give advice, they can represent a party in person or in writing, they can draft any required documents or correspondence, they can negotiate a settlement, they can draft a settlement agreement. But it has to be within the items on my previous slide, and there has to be a proceeding or an intended proceeding. A paralegal can't act on an appeal of a matter that was in scope but is no longer in scope. So for example, you know, some tribunals have internal reconsideration processes. And so a paralegal could act on that because the tribunal would the tribunal would hear the reconsideration in the internal appeal process. But for example, at the small claims court, an appeal would go to a higher level of court, and paralegals that are out of scope for paralegals. So a paralegal could not act on an appeal of a small claims court matter. Does anyone have any questions about scope before we move on? Okay, so now we will talk about how paralegals become licensed. And, you know, other than the very few exceptions, the vast majority of individuals who become licensed have to meet 3 requirements. They have to have graduated from an Ontario accredited paralegal education program. They have to complete the paralegal licensing examination within a certain amount of time, and they must be of good character. Those second 2, completing the licensing examination and being of good character requirement is the same for paralegals and for lawyers. The licensing examination, there is only 1 licensing examination for paralegals, whereas there are 2 for lawyers. But graduating from an accredited paralegal education program, that is, lawyers have different requirements. We do not, as I mentioned, regulate legal education law schools in Ontario, but we do regulate paralegal education programs. So I'll go through these in a little bit more detail. The education programs, they have different entry requirements. So they are at colleges throughout the province. Some programs only require a high school diploma for people to attend the program. Others require post-secondary education before applying. The programs are also of varying lengths, but they do have minimums that we require. So at minimum, they have to be 830 program hours. This includes 590 hours of compulsory legal courses, 120 hours of other courses, and 120 hours of field placement. So those compulsory legal courses are 18 different courses that we require colleges to teach. These are things such as advocacy, alternative dispute resolution, but also items such as practice management and operating a small business, because many paralegals do go on to open their own practice, ethics and professional responsibility. The field placement component, which, as I said, is a minimum of 120 hours, so it can be more than 120 hours. This mimics the articling requirement that lawyers have. So lawyers in Ontario need to attend articling, which is, you know, working with a lawyer. It's currently 8 months. That was a change that was made very recently during COVID. It was before 10 months, and I believe that 8-month requirement is actually just for the short term, you know, while we deal with the fallout of COVID-19. Obviously, the field placement requirement for paralegals is much shorter. So 120 hours, that's about 3 to 4 weeks of full-time work. The other difference is that for an articling position, the law student is responsible for securing their own articling position. The law schools do not. They assist, but they're not responsible for it. For field placement, the college has responsibility for securing the field placement for the student. So once they've graduated, which can take anywhere from, you know, a little less than a year to a number of years, the paralegal education graduates become eligible to register for a licensing examination. And I'll talk in a moment about what the licensing examination actually includes, but the candidate, from their perspective, has 3 opportunities to write the licensing examination within a 3-year period. If they write the licensing examination 3 times and they do not pass, they can apply to write a 4th time within that 3-year period. Once that 3-year period lapses, or you know, they've written 4 times, there's a minimum of a 1-year pause. After that, individuals can apply to re-enter the licensing process again, but they do need to show exceptional circumstances, both for the 4th right and for to re-enter after the pause year. And then the good character requirement, and this is the same for lawyers and paralegals. the licensing candidates fill out a good character form that includes a number of different questions, things such as have they had judgments entered against them in an action involving fraud, allegations of misconduct while attending school, being found guilty of an offense. If they answer yes to any of these questions, it becomes subject to the good character review process. It's there's many stages that that it can go through, but most licensing applications are cleared or resolved and are returned to the licensing process. Only a very small percentage of applicants are ultimately referred to the last stage in the good character process, which is a good character hearing.
Jess, if I can just interrupt and see if anyone has any questions before we sort of continue. Okay.
Yeah, this is Alice. I have one question. I'm trying to kind of compare the educational requirement for the accredited paralegal education programs with what is required in the United States. About how long would it take to complete the minimum that is required for an accredited program?
It's about a year.
Okay. As compared to how long does it take to get a law degree?
3 years.
3 years. Okay.
3 years, but then you also article. So articling is effectively another year. So whereas for a paralegal, that field placement component is included in their educational programming.
Thank you.
Pleasure. Any other questions? Okay, so I'll briefly go through how the Law Society regulates paralegal education institutions. We do so primarily through what we've developed, a policy we've developed called the Paralegal Education Program Accreditation Policy. We call it the PPAP internally. So if I switch and start referring to something called the PPAP, this is what I am referring to. This is all available on our website if you're curious about it. So this policy outlines how institutions can become accredited, what to include in the application, the fees that are associated. It also outlines the various declarations and notices that programs have to provide to the Law Society on a regular basis. It includes all of the academic and field placement requirements, faculty qualifications, and some matters relating to audits. There are also several forms included as part of the policy, and within the forms, it lists all of the compulsory legal courses that have to be included in the program, as well as all of the competencies that are required to be addressed within each of the compulsory courses. A big part of the Law Society's relationship with colleges is the concept of the program coordinator at the college. So the program coordinator is the employee of the college who's ultimately responsible to the Law Society for the proper running of the paralegal program. And we require that program coordinator to have a number of qualifications, including that they are a licensee, so either a paralegal or a lawyer in Ontario. And in this way, they're ultimately responsible for upholding all of the professional responsibility requirements in their dealings with the Law Society and also in their dealings with the colleges and with the public. Audits are also an important aspect of the regulation of paralegal education. So we go and audit about 4 to 5 programs a year, and every program gets audited once every 3 to 5 years. Generally, for a new program, we'll go in a little bit before that time or on the early end. And we do have a separate audit policy and framework that's specifically for the audits. When we go in and audit, we require a number of documents from the program. So, a roster of faculty and their qualifications, field placement policies. We look at completed assessments. We also go in and speak with them. So we meet with the program coordinator, some college administration, the field placement coordinator. We meet with program faculty and students. And we generally also sit in on at least 2 classes to get a sense of how the courses are being run. The audits last anywhere from, a couple of months for a very well-run program to over a year. So after we've gone in and reviewed the documents and met with them, we produce a report, and we'll have a back and forth with the college to clarify information and for them to be able to fix any deficiencies that were noted. And finally, complaints. So complaints generally come in externally. We only deal with matters that relate directly to the paralegal education program accreditation policy. So for example, sometimes students will write to us and complain about the internal financial assistance policy at a college. That is not something that we would investigate, but anything that relates to the policy, to our policy, we will address with the college and investigate, and generally have a back and forth with the college about any matters that have been brought up. So just to give you a sense of accredited paralegal education programs in Ontario right now, there are 23 colleges. But several colleges have more than one program or more than one campus. So there are more programs than colleges. Of those colleges, one is a French program, but the balance are English programs. And many of them are based around Toronto, with others spread out throughout Southern and Eastern Ontario. There's a split between public colleges and private career colleges. So private colleges don't receive public funding and tend to offer significantly smaller programs and smaller class sizes. So generally class sizes of around 15 to 20 students. The public colleges are much larger and have much larger class sizes and much larger programs. As I said,
Jessica?
Yep.
I'm sorry to interrupt, but this makes me wonder, how many licensed paralegals are there in Ontario? Can you give us a sense of the size?
Yes, I can. Let me pull it.
9,000 to 10,000, somewhere in that neighborhood.
That's right. Yeah.
Okay, gotcha.
Yeah.
So that's okay. Oh, and I was going to ask, how did that compare to the number of lawyers? But I see that here. So you've got 55,000 lawyers and almost 10,000 paralegals.
That's right.
In Ontario. Okay.
That's right.
That are licensed.
Okay. Exactly.
Gotcha.
And we'll talk about it in a moment, but there's also a distinction between who's practicing and not practicing. So we'll get to that in.
Thanks. I just seeing the schools made me think the scale is a pretty large scale. You've got a lot of them. Thanks. Go ahead.
Let me just go back here. So it's when we go in and audit, we're one lawyer and one staff member, and currently we're doing those audits virtually. We also track information from the colleges. So one of the things that we require is it's a cohorted system. So the colleges are allowed to begin 2 cohorts of students per year, and those cohorts need to have a minimum of 15 students in them. And so we have the colleges declare when those cohorts would begin and the number of students that begin in those cohorts, as well as the number of students who graduate from the cohorts at the end. And so that gives us a sense of attrition, which can sometimes be a red flag about a program. In terms of complaints, we receive complaints on an ongoing basis throughout the year. Generally, we're investigating between 1 to 5 different programs at any given time. And these are often brought by students, but sometimes also from internal faculty or administrators at the college. Any questions about paralegal education before I turn to the licensing examinations?
This is Alice Mine. I have one
Yes.
question. So what would be the advantage of the different types of degrees, diploma, degree, certificate, graduate certificate, any one of those, if it's an accredited program, would be satisfactory for getting licensed, correct?
That's correct. But so we have minimum requirements for the programs, but many of the programs that meet those minimum requirements exceed those minimum requirements. And so they offer many more hours in placement. So there are differences absolutely between the various programs, but from a licensing standpoint, anyone who has graduated from an accredited program, whether it exceeds the minimum requirements or just meets the minimum requirements, meets the requirement to be able to become licensed.
So it's an individual preference as to, you know, how educated you want to be.
Absolutely.
Just to follow up to that, is there sort of a marketing advantage to having more certifications or higher certifications?
So there are, oh, sorry, Jess, did you want to answer that? I think I might.
No, go ahead, Panina.
Oh, I was just going to say that there are different perceptions out there, and there may also be different advantages in terms of, for example, someone who gets a bachelor's as part of their program may have an easier time if they want to pursue subsequent education, for example, if they want to go into a postgraduate type of program versus someone with a certificate who may have a harder time because a bachelor's may be a requirement to get into the next program. And in addition, there are going to be different perceptions in the marketplace.
And are these colleges, are they undergraduate? Are they given undergraduate degrees in various areas, or are they law schools? That's my first question. The second is there any overlap between this curriculum for paralegals and lawyers' curriculum?
So there isn't really an overlap, and our colleges, we use the term a little bit differently than what you might use in the United States. So we use a college primarily to refer to either the private career college or the public college, which might have, for example, 2- and 3-year programs, with some of them having some degree programs, whereas the law schools are typically within universities, and those would typically have quite a number of undergraduate and graduate programs. So there are no institutions that I can think of that would have both a paralegal education program and a law program. Jess, you can correct me if I'm wrong on that.
No, I think that's right. And I mean, there might be general overlap in that in law school, you also learn some rules of evidence, and paralegals are learning some rules of evidence. So there's kind of some general overlap, but in terms of the level of education, it is very different at a paralegal college than it would be in law school.
Thank you.
So licensing examinations for paralegals. So lawyers also write licensing examinations. Lawyers have to pass 2 licensing examinations to be able to become licensed as lawyers. They have a barrister examination and a solicitor examination. Paralegals only have 1. It's an open book exam, and the Law Society, internally develops the study materials that the exam is based upon. So it's a self-study exam. We release the study materials once annually, and those study materials support 3 paralegal licensing examinations. The licensing examination is intended to assess candidates to ensure that they are minimally competent entry-level paralegals. And there are a number of competencies that are assessed on the licensing examination. All of our entry-level competencies are online. There is significant overlap between the competencies that are required to be taught in the paralegal education programs and the competencies that are being assessed on the licensing examination, but they are not exactly the same by any means. There are 3 sections in the exam: administrative law, criminal and quasi-criminal law, and civil law. But the competencies are in a number of different categories within those 3 sections. So, for example, ethical and professional responsibilities, the fundamentals and jurisdictions of Canadian law, problem and issue identification, analysis and assessment, the litigation process, practice management issues. All of these competencies are being assessed on that exam. The exam is currently online. That is a change we made very quickly when the pandemic hit. And for the time being, it will continue to be online. It used to be a 7-hour in-person examination. Now that has been shortened to 4 hours. It's made up entirely of multiple choice questions. We put out an examination guide. There are very strict rules that the licensees have to abide by when they are in their licensing examination. And we also provide a number of candidate supports, and these are the exact same for paralegals and for lawyers. So, we meet our human rights obligations and provide accommodations for, pursuant to any grounds in the Ontario Human Rights Codes. We also offer tutoring. So any candidate who has failed an exam can apply to the Law Society and is offered up to 5 hours of tutoring at no cost to the candidate. And we match them with a tutor and kind of set that up internally for them. And finally, we have a member assistance program. So that's available to all of our licensees and their families, and it's also available to any candidates within the licensing process. It's funded by the Law Society, but it operates independently of the Law Society, and it provides a number of services such as peer support and counseling services. So I'll pause. Any questions about the licensing examination before we move on to some trends?
What is the pass rate, Jessica?
We do not disclose the pass rate, but I can say that it's not marked on a curve. There is a passing standard that is set for every licensing examination, and candidates have to meet that passing standard irrespective of a curve. So I'll take you very briefly through some numbers. You can see them on the screen. And this kind of gives you a sense of the numbers of paralegals as compared to lawyers. And these are all from the 2019 annual report, which is also available on the Law Society's website. So in 2019, about 1,000 paralegals were licensed. That's a little bit less than half of the number of lawyers who were licensed that year. And as we mentioned, there's around 10,000 paralegals who are licensed. But as Penina mentioned, the number of paralegals providing legal services is significantly less than that. It's about a third, 3,700. Licensed paralegals actually providing legal services. So in an active practicing status, that's about 1/10 of the number of lawyers who are practicing law. And that ratio has stayed consistent for quite some time. In terms of complaints, paralegals tend to generate a proportionate number of complaints. So they're about 10% of the licensees in Ontario, and they tend to generate around 10% of the complaints. And about half of the complaints are about service issues. So that means issues such as failing to communicate or failing to serve the client. Those would be considered service issues. And here you can see the breakdown by the area of legal services. So the largest single area where paralegals are devoting at least a quarter of their time is small claims court matters. And then you'll see it's Provincial Offences Act matters. And then the third one is administrative law. But really, really it's about, the math's not perfect, and I'm a lawyer, so I'm not great at math, but it's about a third each. So there's about a third of paralegals who are devoting at least a quarter of their time to small claims court matters, about a third who are devoting their time to criminal and quasi-criminal matters, and about a third who are doing, devoting their practice to tribunal work, such as, landlord and tenant, human rights tribunal, workers' compensation. And now, Penina, I can hand it back to you.
So this is really just to give you a sense of where things are at and where we're going. As you can see from what Jess has discussed, we're really having a similarity across our two classes of licensee. So in terms of rules of professional conduct, trust accounts, insurance, continuing professional development, compensation fund, audits, investigation and discipline. So there's a strong desire to have a kind of matching approach to the two categories of licensee. Do you want to go to the next slide, Jess? And we're almost done. So in the past short while, we've really seen some acceleration of the recognition of paralegals and what they are bringing to the table in terms of access to justice and representation of clients. And they were recently recognized as officers of the court. The scope of practice in effect was broadened, and they became eligible to be appointed as notaries in the same fashion as lawyers. And as you'll see on the next slide, I think there's also movement in terms of the family legal services provider front, because that's another area where there has been a sense that there are a number of unrepresented litigants who would benefit from legal representation. And do you have any questions on that? I think that's about it. Am I correct, Jess?
You are.
Okay, so any questions?
This is Alice Mine again. So one of the reasons we're studying what is happening in other places in the country and in the world is that we're trying to see if there are ways that we can improve access to justice, specifically by bringing the cost of legal representation down. Have you said that your last slide that you're seeing some trends in that way? Is that something you've been able to study? Is there a substantial difference between what a licensed paralegal would charge versus what a lawyer might charge for the same kinds of services? Is it clear that, if you're an intelligent consumer, you're going to choose a licensed paralegal to provide some of these services because it would be economically better for you to do that? Or is there any way to study those things?
So there are efforts underway to do some more analytical work on some of these factors. I think we could probably at this stage only speak anecdotally. And from that perspective, there are certain areas where I would say that paralegals have created, a sort of depth of experience that your typical lawyer licensee might not have. And so there is a value in that regard that in theory would have an effect on reducing costs. So for example, if there's an area that a paralegal has dedicated themselves to, they might have so many templates and practices in place that they can effectively reduce the cost to the client as compared to someone who might only deal with that same area, for example, once a month. And then there's more of a learning curve each time you might be representing the client in that regard. So I think some of the benefits anecdotally are likely going to be seen on the basis of really concentration of activity within a specific area. I think as we're looking at these, I think we'll find that some of the complexities in more complex litigations, so if we think of family law, there are some relatively non-controversial, non-disputatious aspects of it, but then there are some situations that can be quite litigious. So I think that the more litigious something gets, the less you're going to be able to see that economy arising from someone specializing in that area, because every situation becomes, to some extent, fact specific. So there is some effort underway in terms of trying to find ways to analyze the data, but I don't believe that we really have that kind of concrete evidence or information that you might be looking for.
And then another question. If I understand correctly, you can be a licensed paralegal and you can, as we would call it, hang out your own shingle or have your own business, or you could work with licensed lawyers.
That's correct.
So have you all tracked that at all to see, what most licensed paralegals are doing in that regard?
Again, I think there's more efforts underway currently now that we're several years into the situation to really get a handle. I think initially in the first several years, although the Law Society has looked at that kind of information, when you're sort of in that growth stage, it's really hard to analyze the data because it's still changing. And I think now we're at a point where there's a maturity in the market. And I do believe that more of that type of work is underway. If we do develop that kind of concrete information, it gets posted typically on our website. And we can certainly stay in touch with you and let you know if and when that information should become concretized and public.
Okay. Great, thank you.
You're welcome.
Terrific. Any other questions from anybody else on the committee? I thought that was a great presentation, a really good overview of what's happening. And I think it's been, I think we've all learned a lot. So thank you for providing.
I had a quick question, if I can, Mark.
Yeah, go ahead, Brian.
Just one point of clarification. You had mentioned the rules of professional conduct and as you're trying to kind of match the different requirements between paralegals and lawyers. Does that mean that the paralegals have a different set of rules of professional conduct, or is it the same, or is it very similar? What's the status with that?
It's quite similar. Theirs are called, when I say theirs, I apologize. It's just that I mean that as opposed to, because I'm a lawyer, but so there are two sets of rules. There's the rules of professional conduct, and then there are the paralegal rules of conduct. So they're very, very similar. There are a couple of areas of practice that are really unique currently to lawyers. And so the rules have to take some of those factors into account. So there's some distinctions, but if you take a look at them, you'll see a lot of similarity as well.
Great, thank you. The last question I had was just to kind of, I guess, a general reaction. And I know maybe some of this predates both of your times at the Law Society, but did you get a sense of kind of the reaction from lawyers when this program was introduced, when the license was created, then versus now, and how paralegals have really kind of been, I guess, brought in, and I guess you had just mentioned that they had been recognized as officers of the court, and just kind of the general reaction from the lawyer population to the licensed paralegal status?
So I would say, and I don't know, Jessica, I'm going to answer this first just because I'm older. So I've been a lawyer since before paralegals were licensed and after, and I would say that initially, again, anecdotally, not speaking for the Law Society, initially, anecdotally, from my perspective, there was some concern perhaps about what this meant for the profession. But I would say that in the past, at least 5 years, anecdotally, the feedback that we receive is quite positive, that there's really a sense that paralegals have made a very positive difference to the legal professions. So, maybe it's because whenever there's change, there's going to be perhaps some reluctance and people might be a little bit concerned. And then once you realize the benefits that accrue across the board from licensure of paralegals, I think there was a real sort of welcoming. But I do think it took a little bit of time for that pure welcoming to happen.
Great, thank you.
And Panina, could you talked about the benefits across the board. Can you just give us, I realize it's anecdotal as opposed to a study, but what are some of the anecdotal benefits that you're seeing for the profession as a whole and for the public?
So I would say, let's start with the lawyer sort of population. I think there are enormous benefits for the lawyers in that they now have a class of licensees that they really can rely on to work with. So if, for example, they have certain matters that maybe aren't suitable to them, but they can see where it would be perfect for example, a paralegal licensee that they may know, that creates a benefit in terms of referral and a sense of confidence that they've met certain requirements in terms of the trust accounting and the good character requirements and the licensure in terms of the examinations and all of that. So I think there's a real benefit for the lawyers in knowing that there are partners available to them in the sense of people that they can work with on files. I understand that some lawyers and paralegals work together in offices and they split their files according to certain scope of practice requirements. And that's very beneficial because it can help with costs potentially to clients, and it can properly allocate resources as is appropriate to matters and to client and for the benefit of clients. For clients, there's a benefit. There's a category of people whom they know are licensed and regulated and can be sought for legal assistance when matters arise for those people, when otherwise they may have found that there was just too much of a gap to be thinking of seeking a lawyer licensee to be of assistance. So I think that's a real benefit to the public, is creating a new category of like legal professionals, licensed legal professionals to whom they can turn for assistance. And for paralegals, it's been great as well. Many paralegals were very welcoming of regulation when it first came in, because it creates that framework and it really gives them resources that maybe they otherwise would not have had. So I think it's really been, there have been a lot of benefits to all the different stakeholders.
Can I ask something, Mark, so I can figure out the
go right ahead, Colin.
One of the questions I had in this, just sort of anecdotally, do you have contested civil cases where you have a licensed paralegal on one side representing one party and the lawyer representing the other? Is that commonplace or happening?
I can't speak to whether it's commonplace, but I do know of situations, just from having spoken with people casually, where one of the litigants is represented by a lawyer and one of the litigants is represented by a paralegal, because, for example, in small claims court, you will have both paralegals and lawyers representing clients.
Hmm.
Any other questions? I know we do have another presentation, but this is also a great opportunity to have talk to folks where they've done it for a while. So if you've got other questions, go ahead. We'll do it for another couple minutes, but then we're going to need to shift.
It's Joshua Malcolm.
Go ahead, Josh.
So here in North Carolina, there are times where the state of North Carolina appoints an attorney to represent an indigent person in different types of cases, whether it's criminal cases or abuse and neglect over at DSS, and those individuals are reimbursed across the state at the same rate for all practical purposes. Are there similar situations there where individuals are appointed by the government? And if so, between the attorneys and the non-attorneys, are they reimbursed at the same hourly rate?
So, and I can't see Jess's face now, so I'm not sure, Jess, if we want to speak a little bit about legal aid or.
Sure, you can go ahead, Panina.
So we have something, it's not quite the same, and there may be other avenues out there that I don't know about, but we have a concept of legal aid, and that's where an individual can retain counsel, and the funding for that comes through legal aid. It sounds a little bit different from being appointed to represent someone, which might just be a difference in the jurisdictional aspect. And last I knew, which I can't swear to, legal aid was really, it was through a lawyer representing someone. Jess, do you have information on that?
I think that's right. I think that lawyers can accept legal aid certificates, but I'm not sure whether paralegals can, and I'm not familiar with the rates for legal aid certificates or how they differ.
So we would be able to find that information if you wanted, but I don't think Jessica or I ever practiced in that area. So we would actually have to look into that.
Great. Any other questions before we move to our next presentation? All right. If not, we do have folks here from the North Carolina Justice for All Project. And thank you very much, Penina and Jessica. That was fantastic. So
Thank you
before
very
go,
much.
I know you may need to
Pleasure.
go, but that was a great overview. Yeah, I see Alice clapping. I'll clap. We're clapping as well. It was really great. I appreciate you taking the time. Fascinating information. So
And thank you for having us.
yeah.
Yes.
So the next is a group of some paralegals in North Carolina that have put together a proposal in connection with licensure of paralegals. And I know we have several folks. We've got Elisa Mitchell Mercer, again, apologies if I get a name pronounced incorrectly, SM Kernodle Hodges, Rachel Royal, Shawana Almendarez, and Morag Pulaski, I think all here with us. I'm not sure which combination of you want to present, but let me go ahead and turn the floor over to you. And thank you guys very much for being with us. Look forward to hearing from you.
Okay, I'm Alicia Mitchell Mercer. I'm going to do the presentation, and then I think at the end of it, we were going to all answer your questions as a panel if you had questions, if that's okay.
Fantastic. Thank you.
So thank you all for having us here today. You've already said our names, but again, I'm Alicia Mercer. I'm joined by my project team, SM Kernodle Hodges, Rachel Royal, and Shawana Almendarez. We're all paralegal certified by the North Carolina State Bar, and we're all in leadership with the North Carolina Paralegal Division. We also all work as paralegal contractors with attorneys or legal project managers. We are honored to present our proposal for limited licensing. We're here not just as members of the legal community, but as advocates for all North Carolina residents who fall into the access to justice gap. Because of the time, like I said, we would like to complete the presentation and then answer questions if you have them. Over the next 30 minutes, we'll follow this discussion map to address the topics Brian suggested would be most helpful in understanding our proposal. Brian was also kind enough to provide minutes and help us to locate videos from your previous meetings. So as we go, we'll also occasionally discuss statements made by your previous presenters. Access to justice is a precondition for the satisfaction of basic human needs. In the absence of access to justice, people are silenced and stripped of their rights. They're unable to challenge injustice or hold decision makers accountable. You've heard the saying, he who represents himself has a fool for a client. Even lawyers typically hire other lawyers for their personal legal matters. But generally, he who represents himself does so not because he's a fool, but because he can't afford legal counsel. For millions of North Carolina residents, there's no other option but to stumble through the court system alone. And as if trying to understand state court rules, forms, and procedures were not enough, North Carolina has 1,832 local rules and forms to make the process more difficult. But the access to justice crisis is bigger than even law and lawyers. It's a crisis of inequity. Only some people and only some kinds of justice problems receive lawful resolution. And only some people groups have more, access than other people groups. For example, the doors are open to the affluent, but to those of modest means, those doors might as well be locked. Recently, I've heard access to justice framed as access to lawyers, but justice is about the resolution of a problem, the outcome, not just the process of working with the lawyer. And resolution doesn't always require a lawyer's assistance, as we'll discuss with you today. In putting together our proposal, we were inspired by the recommendations of former Chief Justice Mark Martin's Commission on the Administration of Law and Justice, created in 2015. That commission was created to evaluate our judicial system and make recommendations for improvements. The commission was divided into 5 committees, but for this proposal, we'll focus on the Legal Professionalism Committee and 2 of its recommendations. First, the Legal Professionalism Committee recommended the creation of a North Carolina Innovation Center, and that it study possible updates to Chapter 84 to address the changing nature of legal services. They also suggested studying proposed changes to the definition of the practice of law and the entities with the authority to change that definition. Second, they recommended that the Innovation Center study whether North Carolina should license or certify any additional categories of legal service providers, and if so, address how these providers should be regulated. We waited to see what would come of these recommendations, but as far as we know, after the commission dissolved in 2017, nothing further was done concerning the exploration of limited licensing. We were further inspired by other state bars and court systems who were exploring non-lawyer assistance to pro se parties. As you've heard, some of the outcomes include courthouse navigators and facilitators in states like Arizona, New York, and California, and Washington, and legal document preparers in states like Arizona, California, and Nevada. As time passed and we saw no movement in North Carolina with regards to limited licensing, we began researching for our proposal. We looked at Chapter 84 and its history. We reviewed meeting materials from the Legal Professionalism Committee in 2015. We reviewed reports from organizations and commissions focused on access to justice nationally and statewide. And we researched each state for activity concerning regulatory reform of paraprofessionals. After reviewing this information, the questions we had were, do our UPL statutes still serve their purpose of protecting the community from bad actors, or have they become an impediment to access to justice? We know that the UPL statutes create a monopoly. We know that monopolies mean higher prices, and higher prices force consumers to make one of two choices. Either you pay the higher price or you do without the service. We'll cover just a few highlights of what we learned during our research. First, in our exploration of other licensing programs, we looked closely at Utah, Washington, Arizona, and Ontario. The licensing plan we put together takes more features from Utah and Arizona than the other jurisdictions. Arizona has had legal document preparers for 15 years. They can complete forms and offer legal information, but not give legal advice. This spring, they began licensing legal paraprofessionals, or LPs. Utah created its task force in 2015, and by spring 2019, in just 4 years, it began licensing its licensed paralegal practitioners, or LPPs. Program differences are highlighted in red on this slide. The biggest differences are that Arizona has more practice areas in which LPs can represent clients, including limited jurisdiction civil cases, limited jurisdiction criminal cases where there's no jail time, and some state administrative cases. While Utah presently allows LPPs to represent clients only in the areas of family law, landlord-tenant law, and debt collection. Arizona also allows their limited licensees to appear in court, represent corporations, and use contingency fee agreements like lawyers, while Utah allows none of those things. And Utah has mandatory pro bono, and Arizona does not. Second, we reviewed reports from various legal aid entities. You've heard already that in 2017, the Legal Services Corporation determined that 86% of litigants in civil cases received inadequate or no legal help. You've heard that there's only one legal aid attorney for every 8,000 North Carolina residents, and that although legal aid in North Carolina reports that 37% of the state's population is eligible for their services, they can only serve 1 in 10 households requesting assistance. You also likely know that in counties like Robeson, 80% of its population is eligible for legal aid, but most receive no assistance due to a lack of legal aid and pro bono attorneys in that area of the state. We also learned why the justice gap is much larger than even the reports show. First, as you can see, in 2019, the income cutoff for legal aid was $16,000 per year for a single person and $33,000 per year for a family of 4. But as you know, many people make significantly more who still can't afford legal counsel. And the gap gets wider as the cost of living increases and outpaces wage growth. Taking from the work of Rebecca Sandifer, the gap also includes those who don't realize they have a legal problem. For example, someone who's being wrongfully evicted may identify their legal problem as just part of their ongoing financial struggles instead of as a legal problem with possible legal remedies. And of those who realize they have a legal problem, they may not know where to go for help, particularly since legal aid has a reputation for turning away so many people. Now, when the legal community brainstorms ways to fix the access to justice gap, the common solutions discussed are more funding for legal aid, the need for more pro bono volunteers, and greater adoption of technology. We'll spend the next several moments discussing why these options are needed, but incapable of fixing this issue by themselves. First, we'll discuss legal aid funding. In 2019, funding for legal aid in North Carolina was around $28 million. That funding helped legal aid serve the 1 in 10 families who were eligible. The other 9 out of 10 eligible families, I presume, were not served. So it made us ask, how much more funding would be needed to serve all of the people who qualify for legal aid if they could only serve 1 out of 10 families with current funding? And what about the people whose income is above $16,000 for a single person or $33,000 for a family of 4 who have never qualified and can't afford legal counsel? This is why in 2020, Jim Salmon, former president of Legal Services Corporation, said there will never be enough legal aid funding to meet the needs of the public. He challenged the legal community to look at other innovative ways to bridge the access to justice gap, and he suggested limited licensing as one way to meet this need. The second common suggestion is more volunteers for pro bono. In 2016, Professor Gillian Hadfield estimated that if every one of the 1.3 million licensed lawyers in the United States were to take on the nation's legal problems, they'd each have to put in 180 pro bono hours to provide just 1 hour of assistance for unmet legal needs. According to Lawyers Mutual, lawyers average 37 pro bono hours each year. Unless North Carolina pursues mandatory pro bono, it's impractical to think that pro bono is going to make even a small dent in the problem. In fact, Rachel prepared a report for you showing that legal aid has experienced both a significant drop in volunteerism and a startling increase in eviction cases since the pandemic began. The third most common suggestion is technology. In July 2020, Bill Henderson spoke to you about Susskind's 5 stages of evolution, commoditization of legal services, and the transition of legal services from a one-to-one model to a one-to-many model. He also spoke to the Committee on Legal Professionalism in 2015. Henderson suggested tabling the idea of changing authorized practice rules to focus on technology and scalability. While I agree that technology is one piece of the puzzle, there are important issues to consider when having the technology conversation. First, the availability of legal technology. Second, the expectation of access to that technology. And third, the importance of trauma-informed legal advocacy. First, COVID-19 taught us that while many people have smartphones, not everyone has the tech infrastructure needed to use technology effectively. When schools closed, school districts and internet service providers scrambled to provide computers and internet service to families in need. Churches and community centers also offered support by allowing families in need to use their computers and Wi-Fi so children could keep up with their studies. Given what we've learned from that experience, we need to be mindful of access to technology issues when having this discussion, especially when there are so many attorneys who struggle with legal technology themselves. Second, despite Susskind's 2010 prediction of certain doom for lawyers who don't embrace technology, in most areas of practice, legal tech is still at a very early stage of development. As an example, we've had Guide and File. I hope that you're familiar with that by now, but it's on nccourts.gov and it's been there since September in limited areas of practice. Innovations like Guide and File and the coming eCourts initiatives are a wonderful undertaking by the Commission and the AOC, but we have to consider the limitations. Legal tech like Guide and File doesn't conduct a what-if analysis or a Monte Carlo simulation and instruct clients on what actions to take given the infinite number of potential variables involved in their cases. Clients frequently still need an actual human brain to help them with researching legal questions, drafting persuasive arguments, preparing for trial, and negotiating settlements. Additionally, legal tech like Guide and File isn't necessarily appropriate for everyone in the access to justice gap. That's one of the reasons Guide and File nudges clients to seek out legal counsel throughout the process. To explain, on February 19th, Jennifer Simmons, a senior project manager at the Equal Access to Justice Commission, gave a presentation on Guide and File. She shared that there were 20,000 users and 30,000 sessions since September when the system became available. Of that amount, 4,000 users completed the interview process to generate documents that could be filed. Jennifer said she wasn't concerned about the 80% drop off between the number of users and the number of interviews completed because that means Guide and File is properly instructing users to seek counsel when forms don't meet their legal needs. I agree with her, but from another point of view, a drop off of 16,000 users may mean that there's a large number of people who would benefit from additional support when using Guide and File. So sorry. Let me get back there. It doesn't make sense to offer services like Guide and File for those of limited means, but not give them access to reasonably priced legal service providers to help them get through the process when they have questions. Guide and File is exactly the kind of service that technicians could support and complement. Third, we must also take a holistic view of people in the access to justice gap. For example, in our proposal, we shared that 14% of North Carolina adult residents are functionally illiterate. By the numbers, that means about 1 in 7 people in North Carolina struggle to read and comprehend. Many people struggle with receptive language skills, expressive language skills, and other concerns that impact effective communication. Even with the best technology, many people are unable to adequately articulate their legal position. Also, there are a number of situations where important human-to-human interactions would be difficult to replicate in a one-to-many model. This is where trauma-informed legal advocacy comes into play. For example, in a 50B action or in a child custody action, pro se parties would benefit from having someone to help them understand the legal process, clarify and prioritize their legal goals, and help them temper their desired outcomes with reasonable expectations, especially at a time when they're distraught. So I'd say that despite the views of Henderson and Susskind, while tech innovations are essential, tech isn't by itself a silver bullet in resolving our access to justice problem. And one-to-one interactions will always have a place in people law. So we've covered legal aid, pro bono, technology, and one-to-many, which are all important pieces of the puzzle that cannot fill in the access to justice gap by themselves. So what's left? We returned back to the recommendations made by the Legal Professionalism Committee in 2016 and the efforts of other state Supreme Courts and state bars. Before we launch into our high-level proposed plan for licensing, allow me to briefly cover our goals. First, we want to provide a path for every North Carolina resident to have access to affordable legal services, whether that be through traditional attorneys, legal aid providers, pro bono volunteers, or legal technicians. Second, we want to help reduce the burden on the court system by helping pro se parties navigate the legal labyrinth more effectively and efficiently. Finally, we want to increase the number of limited legal professionals who could potentially offer pro bono services to legal aid organizations. So now let's take a look at our proposed limited licensing program. We believe a complement to traditional attorneys, legal aid, pro bono, and legal technology is limited licensing. So we put together a proposal which would allow unlicensed law school graduates and paralegals who have met certain experience, education, certification, and examination requirements to provide limited legal services at a lower cost to the public. First, we determined that the highest areas of legal need are family law, landlord-tenant law, estate planning and probate, debtor-creditor law, administrative law, and expungement proceedings. We believe that there are other areas that non-lawyers could assist with, but these are perhaps the best areas from which to consider a pilot project. As we start talking about requirements for licensure, we suggested a number of ways to fulfill the education requirements from a Juris Doctor to an associate's degree, assuming all include certain foundational courses in law. We also suggest a provision waiving education requirements altogether for paralegals with at least 10 years of documented substantive work-related experience. For the certification piece, as you know, the bar already has its NCCP program, which could be used as a potential pool of applicants. Some people have expressed concerns that we're trying to turn the NCCP program into a licensing program, but this isn't the case. Minutes from the Legal Professionalism Committee in 2015 noted an inquiry asking the bar for its position on limited licensing. The bar responded that the Board of Paralegal Certification had not yet made a recommendation to the Bar Council because it was waiting on data from the LLT program. This is a little odd to us since we know that the LLT program wasn't collecting data, but that's how the idea was conceived for the Board of Paralegal Certification to oversee the program. Keep in mind that under our proposal, NCCPs would qualify for licensure only after meeting the experience requirement, which I'll discuss in a moment. A paralegal certification is just one part of the screening process for licensure. For the experience requirement, we suggest 1,500 hours of substantive legal work within the 3 years before application and 5 years of experience within the practice area in which the applicant is seeking to be licensed. Of course, JDs would be exempt from the experience requirements. For the purpose of this proposal, required experience excludes routine clerical and administrative tasks. The paralegal must show proof that their work includes substantive legal work as a paralegal under the supervision of an attorney in the area in which they would like to receive licensing for at least 5 years total. While some people believe competency comes from law school and taking the bar only, we believe knowledge sufficient enough to offer limited legal services can be passed down through experience similar to the apprenticeships that were the norm until the 1900s. Many successful lawyers, including everyone from Abraham Lincoln and John Marshall to Clarence Darrow and Robert Story Sr., pursued apprenticeship. Additionally, California, Vermont, Virginia, Washington, and West Virginia still offer full lawyer apprenticeship programs, and when complete, they can practice in any area they like. Our proposal for limited licensing limits non-lawyers to a specific practice area with a defined scope within that practice area. The next
Alicia, can I ask a question?
Sure, of course.
So this is Ashley Campbell, and I apologize, I missed it. This was 2 slides before. So in terms of what your proposal is, would you mind repeating that for me? In terms of the number? Yes, and the educational, did you do the educational requirement?
Yes, I did. I didn't go very specific because of the time, but I can be more specific if you'd like me to be.
Well, I just missed it. Sorry. Your presentation is great. It just was fast and I didn't hear it.
I'm so sorry. So let me see if I can get back to the education. So for the education piece, they can have a Juris Doctor, they can have an associate's or a bachelor's degree in paralegal studies. They could have an associate's or bachelor's degree plus a paralegal certificate. And then, they could have 15 credit hours of paralegal studies if it's an associate's or bachelor's degree that is not in the paralegal studies program. And then, of course, all of them would require foundational courses in law. We included, you can see them on the side, but there's civil procedure, contracts, interviewing, investigation techniques, law and legal process, law office procedures and technology, legal research, writing and analysis, and professional responsibility. And then, of course, we are still suggesting a waiver for paralegals who have 10 years of experience.
Okay, great. Thank you.
You're welcome. For the experience piece, we're suggesting 1,500 hours of substantive legal work within the 3 years before application, and then 5 years of experience in the practice area in which the applicant is seeking to be licensed. I think I covered this one. So
this is Joshua Malcolm.
I'm sorry?
It's Joshua Malcolm. I'm sorry to interrupt you. So when you use those number of hours, can you be more specific about that? And I'm sorry, I can't see your presentation, ma'am. When you say, 1,500 hours, 1,500 hours of what, certified by whom?
Well, we would propose 1,500 hours of substantive legal work, and I would assume that work would have to be certified by their employing attorney. Or a number of attorneys if they've worked for more than one.
Okay, thank you.
You're welcome. Additional requirements would include providing references from legal professionals who work in the area of practice for which licensing is sought, and 12 CLE credits each year, including, in our proposal, at least 2 in the areas of professional responsibility, 1 in the area of trauma-informed legal advocacy, and 1 in technology training. We would also suggest that licensees be required to use bar-approved engagement agreements. The agreements should include a statement that the legal technician isn't an attorney and may practice only in those areas in which the legal technician is licensed. The agreement should also include contact information to report complaints to the bar, in addition to a well-defined scope of representation and other provisions covered in our proposal. To initially grow the pool of potential applicants, we suggest a limited time waiver for certified paralegals who have 10 years of experience within the last 15 years. The waiver would exempt applicants from the education requirements, but all other requirements discussed earlier would remain. So that's your high-level overview of our licensing program. I try not to go too deep into the weeds because of time constraints. Now we'll move into talking about the benefits of the program to various stakeholders. We'll start with benefits to attorneys. First, firms that employ technicians could increase the firm's market reach by potentially attracting clients who could never afford attorney's fees. According to the Utah State Bar General Counsel, Scotty Hill, surveys already show that LPPs are bringing in more business, and Dave Byers from Arizona also discussed this benefit. Second, technicians will be able to independently conduct client interviews and prepare and sign work product. This would free up a solo or small firm attorney to work on more complex matters or simply have some coverage while the attorney is out of the office on work-related or personal matters. For attorneys who don't employ technicians, there's a benefit to creating a mutual referral relationship with technicians, as you heard on the Law Society of Ontario discuss. If a technician finds themselves wading into waters too high for the scope of their license, they could refer that business to attorneys who may not have otherwise received that business. Now, I've heard concerns that Washington's triple LTs were charging just as much as attorneys or were absorbed by firms charging high rates. I think we have to consider a few things there. First, we know that Washington's triple LT program failed due primarily to overregulation and that no data was collected for this program. There were also only about 50 triple LTs total because of the high barrier to entry. So the population sample is very small. But I asked Steve Crossland, who's the chair of the triple LT board, and another board member, Christy Carpenter, about this. And they both agreed that the triple LTs in Washington are charging significantly less than lawyers in the same market. They believe that this has always been kind of a red herring argument by opponents of the limited licensing concept, primarily by lawyers. So he stated that they are in the process of completing a study with the National Center of State Courts to collect data to dispute that claim. And they gave me anecdotal stats from Washington via email if you'd like to see more information about that. Moving on, benefits to potential clients include affordable access to legal representation and better outcomes for legal matters where the client would have acted pro se absent the technician's lower fees. Additionally, despite the concerns George Howson shared with you in September, namely that limited licensing would give the impression that the legal community was trying to placate those in the access to justice gap with something less than an attorney, we believe that the community would embrace legal technicians. No one complains that the local tax preparers at H&R Block aren't tax attorneys or CPAs. No one scoffs at a realtor who's not a contract lawyer. There's no outcry from the public that medical care is inadequate when treated by a nurse practitioner. If you were drowning in a pool and you had to choose Mark Enriquez to save you or no one at all, you wouldn't tell him you don't want his help because he's not a US Coast Guardsman. When you're drowning, you want help from whoever can assist you. Right now, the options for many drowning North Carolinians are an attorney they can't afford or nothing. And the reality is that no matter what the UPL statutes say, many people are getting legal advice, many times bad legal advice from friends and family. The harm then is not in giving them an option to choose an affordable, experienced, and educated technician to assist them, but in giving them no other option at all. Moving on to benefits to the community at large, there's a positive economic impact. The economic impact is the cost savings to the state and local economies due to the advocacy of providers in legal cases such as domestic violence, foreclosures, child support, and eviction proceedings. When people receive adequate legal services in these areas, there is less need of support from homeless shelters, temporary housing programs, government welfare programs, and community-based programs. This saves money, and those funds can be directed to others in need. And for legal aid providers, licensing technicians would increase the pool of potential pro bono volunteers by nearly 40%. Many paralegals and law school graduates would embrace the opportunity to be involved in pro bono and legal aid efforts in a more meaningful, autonomous way. There are also benefits to the court system, particularly during this pandemic. Technicians could help reduce the strain on the court system by reducing dismissals and do-overs caused by insufficient legal filings and delays and continuances due to people who don't understand state and local procedures or processes. Having an intermediary could also lead to earlier resolutions of simple disputes between parties, which would have a positive impact on case flow management. This could also reduce tension between court personnel who can't offer legal advice and the person who doesn't know what to do. Finally, we discuss benefits to the state bar and technicians. According to the Board of Law Examiners, there are 7,000 law school graduates who attempted and never passed the NC bar exam between January 2010 and July 2020. There are also approximately 4,000 NCCPs. With this potential pool of limited licensees, there is a significant source of revenue from membership dues should this program be housed under the state bar. This program would also give JDs who've not passed the bar a bona fide position in the legal community. There are a number of states like Wisconsin that allow diploma privileges, meaning you can practice law after graduating from law school without taking a bar exam. States like Louisiana, Oregon, and Pennsylvania have already followed Wisconsin in this practice as a response to the COVID-19 crisis. This program would also improve economic mobility for paralegals. So we covered many of the benefits to stakeholders. We don't really have enough time to cover survey and funding, but Shawana Almendarez can answer any questions you might have if you want to know what our feedback looked like for the surveys that we sent out. Brian asked me to address.
Joshua,
I'm sorry.
it's Joshua Malcolm. I have a couple of questions.
Okay.
So under the North Carolina Medical Board, the North Carolina Medical Board supervises a number of other professionals to include nurse practitioners and physician's assistants. With what you're proposing, and those nurse practitioners and we'll talk about PAs, those physician's assistants are the medical doctors, their supervising physicians are fully responsible for those PAs to include their liability. With what you're proposing, would these technicians be totally independent from what I'll loosely refer to as a supervising attorney, or would they have the equivalent of a supervising attorney?
We are proposing complete autonomy from the supervision of an attorney like they have in Arizona.
during your discussions, have you considered what I'm bringing up now, that perhaps another model is that the technicians would have a supervising attorney who would be responsible for their activities, liability and otherwise?
I think that we did consider that. I think that the issue, from the outside looking in, that we're running into is that, I've worked for firms. I can't even get an attorney to agree to, let a law student intern come into the office because they don't want to be responsible, for them. I think it would be difficult for licensees to find attorneys who want to be on the hook for their behaviors when they're not working in the office with them every day.
Sure, and I don't disagree with that, but I just happen to be sitting in a parking lot in front of an urgent care, and I'm sure just like you, on occasion you've been to an urgent care, and the person that actually probably saw you for your medical conditions, which I would say probably a little higher on the strata of importance perhaps than a legal issue at the time. The medical field's figured out how to have this relationship. Do you think that's something the state bar should consider as it's talking about this perhaps paradigm shift?
I think that should be left to people much more intelligent than me. I think that the state bar should consider every option for increasing access to justice. I think that with the urgent care situation that you're talking about, those professionals are working with and in the same buildings as their supervisors. With what we're looking for is more autonomy so that they can be more independent and reach more people in their communities. I think it's just more difficult to do it if you're going to make there have to be a supervising relationship with an attorney. I think you're going to run into some of the same issues and barriers that exist right now.
Yeah. Well, actually, the supervising physician is not in the building, and I think perhaps and I'm just talking out loud, the distinction maybe is that the insurance companies and the urgent care centers and the hospitals have figured out a way to bill for those PAs medical services. So it makes it financially advantageous for them to consider expanding those services by using these, what I'll refer to as mid-levels. So anyway, I didn't mean to take the conversation in a different direction. I just wanted to know whether that was a consideration as you all presented or prepared this
I've seen that model also. That's not what we're asking for here, but I've seen that model in the mental health field as well. I think that there are psychological associates that can offer mental health services in that same kind of way, and psychiatric associates that do the same things. So, that's certainly something that you all are welcome to consider. That's just not what we're asking for in our proposal. So to implementation, unless you have any other questions.
No, I'm sorry to interrupt you.
So Brian asked me to address the issue of implementation. Clearly, I don't need to tell you how to create a licensing program, but the data collection discussion seems to be evolving, so that's what I'm going to focus on here. One big concern the subcommittee has expressed is the lack of empirical data from other state programs, but at the same time, I've heard the subcommittee speak positively about innovation in general. While it's helpful to have some data before beginning a project, data doesn't always precede innovation. Experimentation is a crucial part of innovation, and some would say that there's no innovation without it. At our last monthly roundtable, Justice Simonos said Utah is collecting data as they go along. We know that Arizona is doing the same. These states have accepted that making an idea or concept into reality has thousands of variables that you can't always figure out by discussing it around a table. In a case like limited licensing, where there's a great potential for high reward versus the risk, it's worth experimenting to obtain insight, especially since experiments result in meaningful data early in the process when it's still possible to change the direction or the trajectory of your project. As you can see by these charts, with the planning chart on the left and the experimentation chart on the right, and characteristics on the y-axis and time on the x-axis, the earlier we start experimenting and collecting information, the quicker we can reduce the level of uncertainty. This is what Utah's regulatory sandbox is all about. As far as capturing data during experimentation, I'll briefly address some issues or ideas to create a meaningful data-driven process. Part of this process should include defining the categories of data you want to collect from technicians and other stakeholders. I think that we sent you documentation showing the information that Utah is collecting for low to mid and mid to high risk innovation proposals in their sandbox. Some of that information is on this slide. After creating a schedule, budget, and other guiding documents for the project, as well as identifying stakeholders and the scope of licensing, I would suggest focusing on your quality baseline, success criteria, and key performance indicators to measure whether the project or the program is doing what you want it to do. It also includes making sure your definitions of success and done are clearly defined from the beginning rather than left to the subjective opinions of those regulating the programs like we saw in Washington. You'll also want to create a risk management plan, perhaps with data analysts and legal academia, that includes identifying potential risks to stakeholders, a plan for mitigating those risks, and an analysis of collected data to identify harm and other data points. I'd suggest regular meetings, perhaps quarterly, to discuss the data and areas of opportunity for improvement, and have a change management procedure in place to manage modifications to the licensing program as appropriate. I'd also suggest a communication plan to share information with stakeholders, particularly if any changes to the program affect the way that technicians communicate with clients in the sandbox or in the program, whatever you want to call it. And then you'd continue to measure and monitor progress to making necessary adjustments to the program each quarter until it's producing the outcomes that you want to see. Realistically, we think a pilot program should last 2 to 3 years to really give it a chance to succeed. And then after the pilot project is underway, since I heard you ask Ontario and I think a couple of other states about their evaluation procedures, you might want to consider an independent evaluation by the Public Welfare Foundation, the American Bar Foundation, or the National Center of State Courts. All three were involved in evaluating the LLT program in Washington, and they gave the program favorable feedback while also recommending important changes to the program. As we near the end of our presentation, I want to touch on 2 concerns that are linked to this proposal. And I have to tell you, everybody, not everybody, but a lot of people told me not to even bring these topics up, but they're inextricably linked to the proposal. So I have to address them, right? So the first is competition, and the second is harm to the public. The access to justice spectrum is broad. There are people who make in 1 week what attorneys charge in 1 hour. But according to Pew Research, there are also middle income North Carolina families making just over $78,000 per year. Most demand is in the low to moderate income populations, but the World Justice Project reports that 50% of middle income consumers also go without representation in many civil matters. Many people have the ability to pay something for services, just not the high rates or the 5-figure retainers lawyers are charging. So instead, these consumers go without legal services, or they file pro se complaints and motions and they clog up the court system. That's why the National Association of State Courts says the LLTs don't appear to assist customers who couldn't afford lawyers, therefore they don't compete directly with lawyers. Additionally, affordable legal services are in the best interest of North Carolinians, the court system, and the justice system as a whole, even if they may not be in the best economic interest of lawyers. And I know that this is a sensitive topic. I do not intend to offend anyone. But speaking as a member of the legal community and having watched people lose everything because they couldn't afford counsel, the profession should want the public to view lawyers as trusted advocates, as allies, rather than as disinterested business people. The legal profession has a duty to serve the broader needs of society. Otherwise, we're sending the message that we're content to sacrifice the well-being of millions of North Carolinians to preserve lawyers' economic interests. I'm sorry, I need to take a drink of water. Okay, and then I cannot remember who asked me the question about the medical providers earlier, but you'll probably remember that the medical profession faced the same dilemma some 40 years ago when Congress told the profession that it was not serving the consuming public. It was at that juncture that the medical profession began to see the advent of nurse practitioners, physician's assistants, and other qualified medical providers, even over the protest of nurses and doctors at that time. Concerning harm, in January, you heard Dave Byers, the administrative director of Arizona Courts, explain that Arizona has had legal document preparers for 15 years. He said that they're making a difference in Arizona and that their LDPs he'd like to clone because of the impact they're having in their communities. He also said that the LDP program has been so successful in Arizona that they're beginning their licensing program this spring and that they'll be able to represent clients in court. Byers also informed you that Arizona modeled its program off of Ontario's licensed paralegal program, which began in 2007, and that Ontario's 3,700 active paralegals and 38,000 active lawyers are thriving. Today, Ontario confirmed that statement. There's no evidence that Ontario and Arizona's paraprofessional programs have depressed those legal markets at all. And the number of complaints concerning harm filed in all jurisdictions are less than or equal to those against lawyers. There's also no concern for harm at our federal court level in areas where non-lawyers are permitted to represent clients. And finally, despite Washington's highly controversial and politicized reasons for sunsetting its LLT program, neither harm nor depressing the market for Washington's lawyers were named as reasons for that decision by their Supreme Court. We know that North Carolina legal technician program would not by itself eradicate the mounting crisis in access to affordable legal services, and we aren't insisting that a program must look precisely like what we propose. We continue to learn and we receive input from people all the time and think of better ways to do things. However, limited licensing is in general a critical piece to the puzzle, and if administered well, it's one way to significantly narrow the access to justice gap. Despite apprehension about relaxing UPL, we believe the size and severity of the access to affordable legal services issue outweighs the concerns. We also believe that most, if not all, concerns can be properly addressed through appropriate oversight. As final thoughts, attorneys are the protectors and defenders of society. You guys are the heroes. You're the rock stars. Unfortunately, you're also financially out of reach to most people who need you. There are real people with real problems who are suffering under the weight of UPL restrictions, and the bar has a window of opportunity to be the champion for this change. Justice delayed is justice denied. We appreciate your invitation to share our limited licensing proposal and our thoughts, and we will do our best to answer any additional questions that you might have. Thank you.
Thank you, Alicia. That was a fantastic presentation. I really appreciate the depth that you went through. You covered a lot of ground, which I appreciated, and I love the way you've tied in to things we've learned as the committee has moved forward and referenced some of our earlier speakers. That was really impactful to me, and clearly you've spent time looking at the different recommendations and potential objections, and I really appreciate you doing that. And I think you did a great job. We do have a few more minutes left. For those of you worried about the court navigator, I don't think we're going to have time to discuss it this time. We'll do that again, and there's materials. Let's spend what time we have with the folks from the Justice for All project, and let's open it up for some questions from our committee members for them.
Mark, this is Alice.
Yes, go ahead, Alice.
Alicia, that was a very impressive presentation for all the things that Mark noted, that you brought in what we've already looked at. You looked at what's going on nationwide, and you just presented it in a very cogent and very professional manner. And it strikes me that you all have done a lot of very careful thinking. So what is your thinking on, how do we move this from idea to actuality? I mean, what is your plan in that regard?
I'm waiting for somebody else to pipe up, so I'm not the only one talking. Kernodal, do you want to answer that question?
We had several conversations about what it could possibly look like, but not being sure of what avenue we needed to take to get that done or get that information. We're hoping that from speaking to commissions and committees and you guys, that we'll be guided in the right direction. We would love to be a part of the process to make this a reality for the state of North Carolina, but we're going to need some direction. And if you guys are willing to put us in the right direction to get it done, that would be great.
I have a question to follow up on with Alice. I think the question may be
go
to Alice.
ahead, Ashley. And Mac, I saw your hand next. Go ahead, Ashley.
And I just want to repeat what everyone else said, which is I think that presentation was great. So Alice, from the perspective of this group and the State Bar, if this group supported the idea of expanded access through paralegal licensure, how would that work? Would the paralegals have to lobby the legislature for a change in the law? I mean, we don't lobby. How does all that work from the perspective of the State Bar?
So Ashley, was that a question for me, Alice?
Yeah.
Yes, or anyone.
Yeah, I think it's to you, Alice.
We have Alicia here too. I want Alicia to answer because she's so good. Well, so that was partly my question, Ashley, to Alicia, is like kind of how this group has envisioned a way forward. Right now we have some pretty clear unauthorized practice of laws legislation statutes. And I think it would require a really careful study as to whether we would need legislative authority. I think to create an entirely new licensed group of people that particularly can appear before the courts, we would have to have some legislative changes. From my perspective, I would want the state bar to be involved in any kind of initiative in that direction, as opposed to being responsive to it. To be proactive and participating in it, I think would always be better for our interests. But you know, the line I think is really clear in the UPL statutes between appearing before the bar and being behind the bar. And I do think at a minimum, if we're talking about enabling people to appear in some type of court proceedings, which is, I heard they were talking about landlord-tenant in particular and family law, I think that would require some legislative changes.
Mac, I think I saw your hand. Go ahead.
Thanks, Mark. Alicia, I'm curious about something. I like the proposal. It seemed to me that some of the barriers to achieving it were a fair amount of education and then the practicum stuff that goes after that. I'm curious whether y'all built those in because you thought that's what's really required to do this competently, or you built it in that high as an effort to keep the practicing bar from opposing it?
So I think that we're thinking about certification as part of that piece. And I think up until a year or two ago, there were certain education requirements that you already had to meet to be an NCCP. So we're a little bit different in this proposal than, say, Utah or Arizona, because we're really relying on the experience piece, the 5 years of working under an attorney in that particular area of practice for that experience. We think that the experience is not more important than the education, but just as significant, if not more so. And so we're relying more on the experience piece, and then they can have anything from an associate's degree in paralegal studies to a JD. I don't know if that answers your question.
Well, here's my concern, and Brian, I need your memory to help me with my question. Was it the state of Washington that abandoned their program because the barriers to entry were so high that not that many people applied? So a good idea died because it was too hard to attain for the number of people that would have made the results worth it. Am I getting that right? Was it?
Yeah, I would say, and Alicia, I know you've looked at the program too. My thought on the Washington program was that the like you said, Mac, the barriers were very high. And I think that's what led to the lack of successful applicants. You know, there were only, I think, as you mentioned, Alicia, probably less than 50 triple LTs at the time they sunset the program. The program shutting down, though, I think was, from what we can tell, is a very political decision. There was I think a shift in the Supreme Court. I remember there was a dissenting justice after they made this decision. The Supreme Court made their decision that one justice felt compelled to really kind of note her objection to it. So I think it was kind of a combination of high barrier led to low overall numbers, which created economic concerns for the future and the viability of the program. And that really kind of opened the door to those that did not like the program, perhaps in the first place, or just didn't feel like the program was worth supporting, to go ahead and sunset the program. And I think what Alicia is proposing, what her colleagues are proposing, is it's something that is it seems more attainable. It's like there's some parallels between the certified paralegal program, but those, from what I'm seeing, Alicia, just in the quick glance here and looking at your materials, they are higher than what we have for the NCCP program. There are some, like, Juris Doctor, you're qualified to sit for the NCCP exam. But I understood, Alicia, your proposal is associate's degree plus paralegal certificate, or associate's degree or bachelor's degree in paralegal studies and things of that nature. And then the 10 years of experience, I think, is one of the other kind of abilities to qualify for the exam. And I understood that to be another component as well, that this only just really qualifies you to take the exam. You still got to pass the exam. And I think that was one thing, Alicia, that we probably didn't get enough time to talk about, but I saw you had kind of a practice-based exam. Would you imagine it being something similar to the bar exam?
I would imagine it being something similar to the legal specialization exams that you have.
Gotcha.
Go ahead, Colin.
I'm sorry. And I don't know, but would it make any sense for us to try to look at some empirical data as to where the most egregious problems were, and like perhaps small civil claims of some dollar jurisdiction, and maybe family law issues, and try to look at, if we're going to do this, whether something can be tailored to meet those things. I mean, my impression is in the criminal law business, we have an appointed court system for people who have certain levels of serious crimes and things like that. And so that need seems to be being addressed, but it seems like there's the family law courts seem to be clogged with pro se litigants that are taking a disproportionate amount of time and making it difficult for judges to move the docket and to fairly hear those things. And also the small civil claims that people just don't seek a lawyer because they don't believe they can afford it, whether they can or not. But it seems like those are problem areas, and maybe we should try to identify the problem areas and then see if it seems reasonable to tailor a solution to, at least in the beginning, to deal with those rather than a complete look at a bigger licensure type issue.
Alice, did you want to respond to Colin?
Yeah, I did, Colin. So the Equal Access to Justice Commission has done a civil legal needs assessment. They hired statisticians out of UNCG, and they're releasing their report. We're actually going to have a presentation by Justice Earls, who heads up that committee, at the April council meeting. But that's exactly the things that they were looking at, is like, where are we failing to meet these civil legal needs? So it's great because that work has kind of already been done in a very scientific way. And I think that information will be helpful in sort of informing this kind of discussion going forward.
Okay, thank you. That answers my question. I just need to be patient and we'll get some
well, Mary Irvine is more involved with this than I am, and maybe Mary can provide some more insight on that too. I think she's on the call.
Right.
Mary, are you there?
Sure. Yeah. No, I mean, I think what you said is right, Alice, that the launch is scheduled for April 9th, and there's a very, very long report from the folks at UNCG with all sorts of charts and data. The version that's going to be shared is going to be something that we would anticipate folks to actually read. But if there's specific data, I mean, certainly we could dig in and try to, get some information that would be most helpful to this discussion.
I'm going to leave, but I think it's good discussion, so I'm going to let you guys keep talking. I guess my thought too is, remember, as a study committee, we're really trying to get big ideas. So it is interesting, and I appreciate the detail in this proposal about exactly how many hours and the other things. I think my vision would be, we may say this is something the bar should look at and then begin really crafting that. I like the graph about innovation and where we are, and I think moving quickly is important because we have a lot of unmet needs, but I don't know that we don't have to spend a lot of time right now on whether it should be 1,500 hours or 1,000 hours or those kind of things. I envision that may be another committee. I think ours is to say, is this worth more exploration? We got a lot of great information on that. Brian, I'm going to hand it off to you just because I've got a client waiting for me on a 4 o'clock call that I need to move to. But this has been a great discussion. Again, thank you so much for everyone participating, and keep going. I'm going to have to go, but I'll let you guys keep talking.
Great, thanks, Mark. Well, on that note, certainly want to make sure that everybody has an opportunity to ask any questions they may have of Alicia and her colleagues here on their proposal. And I will say that because of the live streaming requirement through my screen, I can't see everyone's faces if you're physically raising your hand. So please feel free to just unmute yourself and ask away.
Okay, Brian, this is Mac.
Thank you, Mac.
Back to Alicia. I want to follow up on Colin's point about picking a couple of areas of law that we would start with. If we were going to do that, what would your recommendation be for the areas of law that we would have those specialties in?
So from my conversations with Jennifer Lechner, I think that family law has the biggest area of unmet legal need. Rachel, do you have an opinion about a second or third option?
I think in the wake of COVID-19, landlord-tenant is definitely something that I've seen a big need in, especially in legal aid projects as a legal aid volunteer. So especially evictions right now. I know that as is in the report that we gave to you about legal aid, almost 90% of legal aid cases right now are eviction based. And the majority of those have short deadlines. So the volunteers for legal aid projects have been almost grounded because they're not able to assist with those things. So legal aid is definitely, I think, taxed with those types of things, and they could definitely use some statewide support.
And I would like to interject that when we conducted our public survey, 67% of the individuals said that they had issues with family court, that they would like to see the limited licensure happen in that particular area.
That's great. Any other questions that anyone may have?
I can offer just a specific example while we're on the topic of family law, where I think our statutes and the construction of the way the court operates could be far more efficient and may benefit from a model like this. And that is, right now, there's a statute that says thou shalt go to mediation before you can have a hearing in custody. That's true of virtually all family law, but we have parents of children who can benefit from that. It's provided free or nearly free by the state, and there are mediators in all the counties that do that. You have to take, I think maybe in all counties, but in Guilford County, a 4-hour educational parenting class before you get to mediation. So parents benefit from that process, no question. The problem is you've got to file a complaint before you do that. You've got to meet all the statutory requirements of the UCCJ, the Uniform Custody Jurisdiction Act. And all that is to get, I don't know what the percentages are, to be honest, but a large number of cases settle when the two parents and a mediator sit down. No lawyers are invited to that mediation. And if we had a better process, and when we talk about a summons and issuing summons and complaint, and it's all about process, and it's hard for people. And it's just one example of one area of family law that could benefit from some alternative model. And thank you for your presentation, Alicia, and all the paralegals. It's clear that you all have a passion for this, and we need it. And we've got to address the gap in access to justice.
Thank you, Steve. I know we are approaching 4:10. I want to be respectful of everyone's time, but wanting to make sure that everyone has an opportunity to ask any questions they may have as well. Any remaining questions? All right, seeing none. Alicia, thank you. Alicia, Shawana, Rachel, and SM, thank you for joining us. We greatly appreciated you taking the time out of your day and providing us with these different materials and for the overall presentation. I'm sure we'll continue communicating. I don't think this is the last time that we'll be speaking with each other. But I guess I also want to thank everybody who is watching on YouTube. And I feel like that's a cheesy thing to say, but I will let everybody know we had over 70 people watching this particular stream during this meeting, which is one of the higher rates of folks that were watching this during one of these meetings. So thank you to all of you. Feel free to subscribe to the State Bar's YouTube page. But nevertheless,
Ryan, your numbers are up.
you know,
Change.
we're going to go viral with this. But nevertheless, we will be in touch. Certainly, we're not going to have another meeting before the April quarterly meeting, but Alice and I will be talking with Mark about the next steps for our next meeting, and we will be in touch with everybody shortly after the upcoming April quarterly meeting. Everyone stay safe out there, and a great meeting. Thank you.
Thank you for having us here.
Thanks, everyone.
All right.
Thank you.
Bye-bye.
Thank you again. It was a very good presentation.
Thank you.
Brian, you there?